of the meaning of equality under the law. Although the issue of protecting civil liberties was in the forefront at the nation's founding, as we discussed in the last chapter, the issue of guaranteeing civil rights reached the national agenda much later. When we talk about civil rights in the United States, we mean the rights and privileges guaranteed by the government to all citizens under the Equal Protection and Due Process Clauses of the 5th and 14th Amendments and the Privileges and Immunities Clause of the 14th Amendment. These rights are based on the idea that the government should protect individuals from discrimination that results from inherent characteristics. Inherent characteristics are individual characteristics that are part of a person's nature, such as race, religion, national origin, and sex. The Constitution imposes constraints, civil liberties, and responsibilities, civil rights, on governments, which includes government officials and employees, but not on private individuals or organizations. However, government can write laws that prohibit private individuals and organizations from infringing on civil liberties and civil rights. For example, the national government enacted the Civil Rights Act of 1964, which prohibited private businesses and organizations from discriminating in hiring decisions based on the inherent characteristics of race, color, religion, national origin, and sex. Most people agree that no government, private individual, or organization should treat people differently because of these inherent characteristics. The courts have determined that treating citizens differently based on their inherent characteristics is unfair, arbitrary, and in most situations illegal. However, people and even government officials, including judges, disagree about whether the list of inherent characteristics should include characteristics such as age, physical and mental disabilities, and sexual orientation. For example, should the government guarantee same-sex couples the same right to marry, and hence have the same legal benefits of marriage as it guarantees to heterosexual couples? Moreover, there are debates over if and when the government should allow differential treatment in order to fulfill its mission. As we looked at last chapter, no civil liberty is absolute. There are situations in which the government may infringe on an individual's liberty. For example, the government may infringe on an individual's freedom of speech if it views her speech as violating the imminent lawless action test or incitement test. The risk of harm from the speech is highly likely, and the harm is imminent or immediate. Civil rights are also not absolute. The national courts have established tests that the government uses to determine when unequal protection under the law, that is, differential or discriminatory treatment, is legal. Today, the court uses 3 tests: strict scrutiny, heightened scrutiny, and ordinary scrutiny to determine when unequal treatment is legal. Which test the court uses depends on the inherent characteristic that is the basis for differential treatment. For example, courts view race, ethnic origin, and religion to be suspect classifications, meaning that judges will assume that the laws treating individuals differently because of these inherent characteristics are unconstitutional and violate the Equal Protection Clauses. When the courts hear a challenge to these laws with suspect classifications, they use the strict scrutiny test, which means that the government must show that the differential treatment is necessary for it to achieve a compelling public interest for which it is responsible. Using the strict scrutiny test in Loving v. Virginia, 1967, the Supreme Court determined that laws barring interracial marriage violated the Constitution because there was no compelling public interest for which the government was responsible. Hence, the laws were not necessary for a compelling public interest. Therefore, today it is illegal to deny interracial couples the right to marry. The courts do not consider the inherent characteristic of sex to be a suspect classification, and therefore laws that allow differential treatment of women and men do not need to pass the strict scrutiny test when challenged. Instead, the courts apply the heightened scrutiny test, also known as the intermediate scrutiny test, in sex-based discrimination cases, which requires the government to show that the sex-based differential treatment is substantially related to an important public interest for which the government is responsible. The heightened scrutiny test is a weaker test, making it easier for the government to justify sex-based discrimination than discrimination based on race, religion, or ethnic origin. Therefore, today, women in the military do not have the same opportunities in combat roles, and hence combat-related benefits, as military men do, although there has been movement on that in Congress lately. The weakest test the courts use when determining if a law allowing discriminatory treatment is legal is the ordinary scrutiny test, also called the rational basis test. Using the ordinary scrutiny test, courts require governments to show that the differential treatment is a rational means to achieving a legitimate public interest for which the government is responsible. State governments have established minimum ages for numerous legal rights, such as the right to marry, the right to get a driver's license, and the right to purchase alcoholic beverages. Many states have also established a retirement age, maximum age, for state judges. These are areas of life where the courts, applying the ordinary scrutiny test, have determined age-based discrimination to be legal. Differential treatment based on age is a reasonable way to achieve some legitimate public interests. Can you determine what the public interests are in each of these age-based differential treatment situations? For most of our nation's history, the law not only allowed unequal treatment for different racial, ethnic, and religious groups, as well as for men and women, but also required this unequal treatment for a majority of the population. Women were not granted the right to vote until 1920, and they faced a wide variety of discriminatory practices. Ethnic and religious groups also faced widespread discrimination, some as a matter of law. For example, more than 120,000 people of Japanese ancestry were forcibly interned in camps during World War II. More recently, following the terrorist attacks of September 11, 2001, the federal government has detained thousands of Arabs and Arab Americans in prisons without providing any criminal due process protections. But probably the most blatant example of discrimination in U.S. history is slavery. This practice was protected under the law, and slaves were considered to be the property of their owners. They had no protection under the law and could be treated in any way their owners saw fit.